As you probably know by now, the Supreme Judicial Court in Massachusetts has issued its opinion in the Karen Reed case, and they found that double jeopardy should not attach in Karen Reed's case, which means that all three charges are on the table when she's going to be retried, scheduled to begin April 1st. Now, we broke down that opinion. We went through some of the analysis. I definitely have some issues with the analysis, but nevertheless, from the beginning, when they were talking about doing this appeal, I told you that it's not going to win. The case law is just simply against her. One way or the other, she's just not going to win this appeal. Now they're talking about appealing it to the federal courts. It's just not going to win. So just, if you're Karen Reed, save your money. Don't waste it on these federal appeals now. Don't get your hopes up and just concentrate on beating this trial that's going to begin April 1st. You assembled a very good legal team and you're going to have to pay them. So save your money, save your hopes, and just concentrate on the trial that you have now. Now, this really brings up another point, and that is that it seems to be very unfair. Because if at the end of the day, all of the juries agree that they agreed to acquit her on charges 1 and charges 3, so who cares if there's really some case law and some complicated legal analysis why you can't bring the jurors back or whatever it is? It just doesn't seem fair. I mean, let's just forget about that process and let's just do what's fair. All the jurors agree that she should have been acquitted on counts 1 and counts 3, and therefore bring them back and we'll do a formal acquittal in court, and now she'll only be charged with charge 2. And that idea is something that I'm going to talk about today in today's video, and also really more importantly is what we can do definitely as lawyers, and something that we hope to see in this next trial, what they can do to try to mitigate this issue. So first, this is really all sparked by a letter that was sent by a juror after this opinion came out, and it was sent to Christina Rex. So she gets all credit for this letter. I'm going to pull it up because she posted it on X. We'll go through the letter, and then we'll talk about this concept. We'll also talk about what trial lawyers could do to try to mitigate this. So here we go. After serving as a juror in the Karen Reed trial and seeing the chaos that has unfolded since, and by the way, just before we go into this, Christina Rex said that this is absolutely authentic. And she knows the juror, she was in the trial, and this is definitely a real juror that sat on this case. So again, we are trusting Christina Rex about this, but she was there and she was saying that this is an actual juror's letter. After serving as a juror in the Karen Reed trial and seeing the chaos that has unfolded since, it is clear to me that the criminal justice system in Massachusetts needs some work. Despite being one of the most progressive states in the nation, so many aspects of our criminal process are antiquated, confusing, and need to be updated. It would not infringe on the role of the jury to require all trial judges to provide clear instructions that help jurors comprehend all aspects of the job they are tasked with. Similarly, so that's number one. We're going to get to each one separately. Similarly, it would not intrude on the jury's function or the sanctity of the deliberative process to require a uniform process for delivering verdicts and verdict slips, particularly in cases involving multiple count indictments. Making these kinds of changes to ensure criminal defendants receive a fair trial seems like the bare minimum our courts owe to those whose liberty is on the line. So before we talk about the practical recommendations here, let's just first talk about this concept of it doesn't seem fair. There's something that doesn't sit well with a lot of people. If all the jurors agree that they were going to acquit her on charges 1 and charges 3, why can't we just bring them back? And the reason is that sometimes you have to sacrifice an exception, because if you start opening up that can of worms, it's going to be very difficult where to draw the line. And then once you open up that avenue, people will absolutely abuse it. And that's where fraud begins. So even though you're right, in this specific case, in Karen Reed's case, maybe all the jurors really do agree that they acquitted her on charges 1 and charges 3. But if we are going to allow now for a process for jurors to come back after their deliberations, and we're going to allow them to change kind of the verdict or explain what they really was going on in the verdict in the jury room or the deliberation room, you can be really opening up a whole can of worms. And where exactly are you going to draw the line? So that is something that the courts are tasked with. And this is one of the issues that came up in the appeal. When do we bring a juror back? When do we bring jurors back to ask them questions? And this was something that was brought up in an oral argument. We discussed it on this channel a few times. And the idea that what they said is that we're only going to bring them back for really significant issues. So for example, if there's racial or ethnic bias that was injected into the deliberations. That's something that's so incredibly important to discuss and deal with that you have to bring the jurors back. And as well, jury tampering. That's also another issue another time when you have to bring the jurors back. But if you are going to allow jurors to come back for any sort of reason to kind of change their verdict or correct their verdict or really explain what they were confused about and correct some of the misunderstandings of their verdict, well, then where exactly do you draw the line? And if you don't have a very clear lines drawn, then people are going to be it's going to be very easy to exploit and abuse that process. And that's what the courts are nervous about. So sometimes one person is going to be factually innocent, let's say in this case, factually acquitted, where all the jurors agree. Let's just say that they all agree, and they all agree that she was acquitted on charge 1 and charge 3. And unfortunately, that person is going to have to suffer the consequences for the benefit of everybody else that's involved in this. So unfortunately, that's just the nature of an unperfect system. Humans are imperfect, and we can't have a perfect system. It's just going to always work where we can always trust people, trust the integrity of the jurors. Things can get changed. People can get to the jurors after they leave the courtrooms and the courthouses and things like that. So, you got to be very careful with this idea. So they only allowed it in very limited circumstances. So in terms of what's not fair, it may feel unfair. Maybe it is unfair. And it's unfair for a person who's really, really absolutely 100% acquitted. But once we open it up, then people are going to abuse it and exploit it. And then you're going to be dealing with more and more people that should not be, let's say, acquitted and end up acquitted than these type of cases where the person deserves to be acquitted when they really, and now they have to stand trial again. That's just in terms of that thought process. But now let's talk about the other two factors here. And then we're going to talk about what we can do as definitely as lawyers to change this. So number one, it would not infringe. We'll just go back to the second paragraph here. It would not infringe on the role of the jury to require all trial judges to provide clear instructions that help jurors comprehend all aspects of the job they are tasked with. So that's the first thing that she's saying for. She's saying is, why can't you make the jury instructions clear? Make them simple. Why does it have to be complicated? Why does there have to be some legal jargon thrown in there? And let me just explain to you a little bit about this idea. The problem is that words have very important meanings, and every word needs to be weighed. So, for example, we just saw in with 27B, Rule 27B. We spoke about this in one of our videos, and we explained that some of the words in 27B need to be defined. So, for example, when it says return, when a verdict is returned, what does that mean, return? And what implications does that have? And we explained return means general. Okay, what does a general verdict mean? A general verdict means on all the charges. So words have very specific meanings in the law, and we can't just change them. So generally speaking, the jury instructions are uniform. They are uniform. And certain jury instructions, when you want to introduce a special jury instruction, it is not so simple at all. And you argue about it, and you want to make sure that if you're going to incorporate a special jury instruction, which means that these are not general jury instructions. So let's say, in a case, let's say murder. So there's general jury instructions for that murder, explaining the charges, explaining the burdens of proof, just other jury instructions. So those are all uniform. They're all created and they're all uniform. But sometimes there's a novel situation in your case, and you need to ask for a special jury instruction. And when you are arguing that with the judge, then it has to be very carefully crafted. And we spend a lot of time on this. And I know I've had special jury instructions, and you have to be very careful. The language has to be directly from the case that you were asking, based on this case. And the language can be very careful, and then they can appeal that special jury instruction. So words have a lot of meaning, and it's not, especially when you're the court and you're telling them what the jury instructions are and you're reading the jury instructions. So you have to be very careful with how you word things. And that's why we're not trying to be difficult here. The courts aren't trying to be difficult, and when we're creating these jury instructions, we're not trying to throw in a bunch of legalese to make things confusing, to make us, sound like we're some sort of, highfalutin profession out there that regular people can't understand. The reason why we're doing that is that these words have very specific meanings. And if a judge goes off of the script, and I've had this, sometimes a judge will go off script and try to explain things. And when they try to explain things, they may not actually explain it 100% correct. And if they don't do that, then that's a basis for appeal. Because then you can argue to the Court of Appeals, here the judge is injecting his own explanation, and that explanation is wrong. And therefore, the jury could have been misled by by explanation. Now, even though the judge is just trying to make things more simple, it still can't, it's too much of a risk. Because we're doing all this work, we're having this whole jury trial, and then it could be that there was a mistake or an explanation that wasn't exactly correct, and that can completely change the verdict and have to have everybody come back and try the case again. Which is why I've seen that most of the time the judges will read directly from the jury instructions and not change anything, and not modify anything, and not explain anything. Okay, so that's why, unfortunately, this is the system that we have, because it has to go this way. Words have meanings, phrases have meanings, legal definitions are important. In those words mean things. Like, you can't just explain things. Okay, but that brings us to the second part. The second part is that as a lawyer, your lawyers can explain things to the jury. That's correct. Lawyers can explain things to the jury. You know why? Because there is a jury instruction which specifically says that the lawyer's comments are not evidence and they're not the law. The law is what the judge gives the jury. So as long as the judge reads the jury instructions verbatim, then there's not going to be an appealable issue, because a lawyer explained things which is not maybe 100% correct. Okay, so as the lawyer, you absolutely have the responsibility, I would say, to explain to the jury. Let me just get rid of this because it's getting in the way. As a lawyer, you do have the responsibility to explain to the jury what these jury instructions mean, which is why I've spoken about before on my channel. What a very, very important part, a very important job of a lawyer is to explain the jury instructions. Definitely the jury instructions that help you. You have to explain them to the jury. Like the common sense jury instruction. I mean, there are certain jury instructions that I always explain to the jury. And especially when you have a case like this, you have to explain the jury instructions. And this brings us to another point. And the other point is that when it comes to jury selection, when it comes to jury selection, this is also so important. And I've seen lawyers, and you've heard from me before on this channel, I've seen lawyers that don't take jury selection seriously enough. I mean, sometimes I couldn't even believe. I've seen seasoned lawyers who've tried a lot of cases. I actually just recently watched a jury selection. I was waiting to have a hearing, whatever. I had to watch the jury selection, and there was like 2 questions asked by the attorney of the jury, and I was dumbfounded. I couldn't believe it. He was an older attorney. It seems like he's been trying cases for a while, and he only asked a couple questions to the jury, and that's not proper. The best way to try a case, especially during jury selection, is to talk as much as you can to the jury, and you want to explain certain things to them. And certain things could be jury selections, and certain things could be to make sure that they're not confused about something. So, for example, one of my questions, usually it's one of my last questions that I ask the jury. Every single jury trial, I do this now. I always ask the last 2 questions are basically the same in every jury trial when I'm doing jury selection. One of the questions is, if you do not hear the testimony, or if you cannot see an exhibit, can you please raise your hand and tell us that you cannot hear a certain answer or see a certain exhibit? I want you to see all the evidence in this case. I want you to hear all the testimony in this case. Will everybody agree with me that if you cannot hear something or if you cannot see something, at that point you will raise your hand and tell the judge, so that we can have that question asked again and answered again, or we can show you that exhibit more clearly. And because I want it to be very clear that I want them to see all the evidence in the case. Okay, that really doesn't much to do with this video. But the other part that I always tell them is that you may be confused by jury instructions. Jury instructions are confusing, and you may not know exactly what the judge means. You may not be sure. And therefore, sometimes you may have discussions amongst yourself what certain jury instructions mean. And then therefore, you may come to the wrong conclusion of what a jury instruction is. I do this every single trial now. So I say, if you are confused at all about any of the jury instructions, will you all agree with me? Please raise your hand if you won't agree, but will you all agree that if you are confused at all, you will say, we're not going to try to figure this out ourselves. We are going to ask the judge. Do you all agree with me that you're going to do that? Okay, and that's why this, if that question would have been asked in this case, this whole confusion may have been not an issue. Because one of the issues it seems to have happened in this case is that the foreman was controlling a lot of the discussion and ruling about what certain things mean and what jury instructions mean. And if I would have gotten them all to agree with me before the jury selection, hey, look, we agreed. We told the attorney that if we have this type of discussion, this type of disagreement about what a jury instruction can mean or confusion, we're going to ask the judge. We all agreed about that. So let's just go ask the judge about whether, partial verdicts or other questions that we may have to clear up any confusion. If you have any confusion at all, and that's why I tell them, please, everybody agree with me. If you have any confusion at all in these jury instructions, any confusions at all for any reason at all, you're not going to just try to decide yourselves what the law is. You're actually going to be going to come back and ask the judge what certain things mean. Okay, and that's something that I think could be helpful for the jurors in definitely in this case. So I think if you're on the Karen Reed defense team and now you're getting ready for jury instructions, there's not jury instructions, but jury selection, that's just one area, by the way. There should be a whole bunch of areas that you go into during jury selection, specifically in this case. There's a lot of different areas we can discuss about what you have to start laying the foundations for in jury selection. So, but this is definitely, as we've seen from this case, definitely one of the areas that has to be discussed. And like I've always said, I know that closing arguments is a little bit difficult because definitely if you have a very, very long trial, like a 30-day trial, and then Judge Cannone only gives you an hour to get through during closing arguments, and then you want to explain certain jury instructions, sometimes it's hard. But something that I always do in closing arguments, I take some of the jury instructions, which I think sometimes can be confusing to myself, and I explain them to the jurors. I said, this is what the judge is about to read you, or this is what the judge read you, and this is what I want to explain to you what this is. And therefore, they get all that explanation from me. And also something else that I always do is that I walk them through the verdict form. I take them through the verdict form and say, look, this is the verdict form that you're about to get from the judge. I'll have it as a slide. And I don't know if Judge Cannone allows slides or what her rules with the slides or not, but I know personally, I'd be fighting very hard to be able to show the jurors some slides in closing arguments. Right? She rules against, if she doesn't allow that, she doesn't allow it. Or she limits you to how many slides you can show. But something that I always do is I walk them through the slides. These are the questions you're going to be asked. This is how you have to answer these questions. And that's why there's no confusion with the verdict form either. Because as a trial lawyer, part of your job, not just to argue your case, but to also get the verdict that you need and that you want and that you're advocating for. And the only way to get that is if the jurors understand the jury instructions and if the jurors understand the verdict form. So even though you're right, it's not a perfect process. And you're right that the jury instructions have to be written sometimes in the convoluted, complicated legal way. That doesn't stop the attorneys from explaining to the jury what these instructions mean. It's a very important part of being a trial lawyer. So that's what you're tasked with. You can't fix everything, but as a trial lawyer, as a lawyer on this case, you can definitely explain to the jurors what they need to know. And if you know that you're going to be cut off in closing arguments, then you can start trying to do that during jury selection. You can start talking about some of the jury instructions then. So that is what I have to say about that. So we'll see. Again, we don't get to see the jury selection, which is something that I also think is unfortunate because there is really a lot of tactical and strategic decisions about what questions to ask. I think it's one of the most important parts of a trial, as you all know if you've been watching this channel. It's a very, very important part of the trial to figure out what to ask the questions of the jurors during jury selection, not just to figure out their bias. It's not just about deciding whether this juror is biased against you. Even if the juror is 100% not biased and they're completely open-minded, still you want to start laying the foundation. You want to start planting seeds in their head about why you win this case. So you got to really figure out what type of questions to ask them. And this can be a full-time job for a couple of days before the trial to really figure out and formulate what type of questions you're going to be asking these potential jurors to make sure that you can really start planting the seeds that you can win your case if you're on Karen Reed's side or if you're on Hank Brennan's side, into the common law side. Either way, it's something that should be given a lot of serious attention to. So that's going to be it for now in terms of the juror's letter. Thank you all for watching and tuning in. If you haven't yet, please subscribe, like, and we will see you next time.